Let's talk a little bit today about trying to get relief from your contract, any agreement you have with another party due to COVID-19. So, recording this in the middle of a shelter in place mandate from California and our local governments here in San Diego. And we are seeing a large volume of requests from clients about how they can get out of their contracts on both sides of the equation. People that want to maintain the contracts and just reschedule, people that need to get out of the contracts because they think they will not have the revenue to pay for whatever that contract requires. So let's look at the ways that you can potentially get relief in a contract due to COVID-19. So the first thing that you're going to look at is the contract and what is in that contract as far as the provisions. Things like termination, cancellation. Another one is going to be a notice provision. What type of notice, how much time with that notice you have to give for a termination or a cancellation. There's going to be other provisions in there that might be helpful as far as, let's say, what happens if there's a breach, or what happens upon termination as far as who gets to keep what rights. Is there anything that needs to be paid? But by far and away, the most important provision to look for in any agreement during this time is your force majeure provision, sometimes called acts of God. This provision is going to essentially be designed specifically for this situation. If this situation with COVID-19 is not a force majeure act of God situation, I frankly don't know what is. It's the first and probably best example I'll see in my lifetime. So force majeure is where you want to look. Bad news is force majeure is most likely not going to be in a commercial lease. They basically, in the entire industry, removed those provisions a few decades ago. So most likely won't be in there unless it's an older template. But most contracts should have force majeure in there. And then from there, what you look at is what specifically is contained in the force majeure provision. Because if the force majeure provision is only drafted very broadly, and it doesn't, let's say, mention pandemics or illnesses or disease or government mandates or things that require people to stay home, things that are going to be specific to what we're actually seeing. And there's a ton of different things that may be in there, and people are starting to actually draft force majeure provisions in new contracts that call out COVID-19 specifically. That might be a little bit too far, but in your force majeure provision, you need to look for pandemics, illness, disease, government mandates requiring people to stay home, things like that are very much related to what we're seeing. Because if the force majeure provision is too broad, it may not technically apply. And keep in mind that the only way to know for sure whether or not you should be legally given relief from a contract based on your force majeure provision is to go to court over it. So the more specifically it's worded, the much easier time you're going to have, or your lawyer is going to have, making an argument that force majeure should provide relief in this contract because it specifically calls out pandemics, illness, or shelter in place, whatever the case may be. So once you've looked at force majeure, once you've looked at these provisions, and you've seen how force majeure is defined, well then what states' laws or countries' laws govern that contract? A lot of contracts can dictate where the law that governs the contract comes from, and different states and definitely different countries are going to deal with force majeure and acts of God differently. So that's going to be another step that's important to check on. Although I would say that most of the time force majeure is going to be relatively similarly treated. Now, what about whether or not your performance of the contract is actually prevented or illegal or impossible, which are the sort of standards you look at for force majeure? There is always going to be one party that wants to cancel and one party that doesn't because they need that money, especially right now. And so, and hopefully, you'll find situations where you can talk to each other and you can work it out, which is number one, what I recommend 100%, because outside of the contract language, if you can work things out that work for both of you, you'll avoid court, you'll avoid these negotiations and arguments and disagreements and focusing on legalese that you have to pay lawyers to figure out. So work it out. Number one, reach out early, try to work it out. That's my number one recommendation. But in the event you get into a conversation and you're trying to get relief from the contract, early termination, something like that, and the other party wants you to stay in the contract, well, that's going to be a difficult argument. And you have to keep in mind that for the person that wants the contract to remain, they're going to say, okay, let's say you have an event venue rental contract and you want to get out of it because you can no longer have an event of a few hundred people. It has to be 10 people or less. And to you, that means that the purpose of this event venue rental is totally impossible. It is totally illegal now, and you can't do it. You're prevented. However, the person that wants the contract to remain in place is going to say, well, you can still pay me for that event venue rental and you can still rent the space. You just can't throw the event that you wanted to throw, and that's on your side of the fence. And unfortunately, you can still perform the contract, which is paying me for the venue. So you can see where force majeure maybe then won't work. And you don't want to go to court again, so that's going to be a difficult conversation. And it is difficult to draw those sort of points together and say, well, yeah, you're right. I could still rent the venue, but I can't pay you. So the purpose of this contract is totally frustrated, which that's another legal theory. Frustration of purpose is a legal theory that's not going to be contained in your contract. And it essentially says that if the purpose of this contract has been so frustrated that it is basically not possible anymore, then there should be relief from that contract. So you can see where frustration of purpose may sort of fill in the gaps that force majeure cannot actually satisfy for relief from a contract. However, it's important to mention that unfortunately, frustration of purpose is a very high legal standard and it is very hard to satisfy, and it is also different state by state. But you can see where there may be a path of negotiation here. If you are up against a party that won't budge, you can allege force majeure, and then if that's not working or they're saying, well, you can still perform, so technically not prevented or illegal, then maybe frustration of purpose. And all of this, again, is to sort of leverage some type of relief from your contract, which I'm going to circle back here to essentially what my number one recommendation would be is reach out to the other contractual party, do everything you can to postpone, reschedule, delay, whatever it is that is being made difficult or prevented by COVID-19, because then everyone's happy. Yes, of course, right now it's unfortunate short term, but you still get to host your event or you still get to do whatever the contract calls for. They still get paid. No one loses out totally on this. And it is going to avoid any sort of long, drawn out legal battles. So, number one recommendation is always reach out early to the other contractual party, see what you can work out, try your hardest to work something out, because even if, going back to a force majeure, even if you have force majeure, and even if you can get them to agree that the force majeure applies, a lot of the time, force majeure won't even actually let you completely out of an agreement. What it usually will do is then give you a period of time where no performance is required or no payment is required that is equivalent to the length of time that the force majeure event occurred. So you could see yourself in a situation where all that you get out of the force majeure is just a delay of a few months, which again, go try to do that first. Delay, reschedule, postpone, going to be your easiest course of action. But in the event that that's not going to work, you really do have to cancel and try to get some of that deposit back or some relief on the contract. Force majeure, frustration of purpose. And then, of course, if all of this just sounds totally crazy and confusing, you have no idea what I'm talking about, please do reach out. We've seen a large volume of these requests. We're getting pretty dang good at it, and we'd love to help out. So hopefully this was helpful, and we hope that you're staying safe, that you're washing your hands 20 seconds, and that you're staying sane despite all the crazy. We'll get through this. Stay safe out there.